All right, we're going to go on the record. Next matter coming before the court is Lincoln County Cause CV-2026-00191. Samuel Valeriano, Raymond Valerio, and Manuel Garcia petitioners versus the New Mexico Racing Commission, Board of Stewards of Rio Desert Downs. Trying to see if petitioner's counsel is present. I'm not seeing his name. On the meet. Is anybody here for petitioners? Any counsel, legal counsel here for petitioners? I see that Mr. Bustamante is on for the Racing Commission, but I don't see counsel for petitioners. Has anybody heard from Mr. Valencia, Mr. Valerio? Have you heard from your attorney, or Mr. Garcia? Mr. Valerio, can you hear me? Mr. Garcia, can you hear me?
Yes.
Have you all heard from your lawyer?
Not yet.
And good morning, Judge. Can you hear me?
Yes, Mr. Bustamante, I can hear you.
All right. Thank you, sir. And is it Judge Sugg? Is that
Sugg,
the correct pronunciation?
Sugg, S-U-G-G, like bug.
Okay. All right. Thank you, Judge.
Yeah. I'm going to have my trial court administrative assistant make a call, but if he's not here soon, then we'll proceed and the relief will be denied. So we'll give it up to 5 minutes. So we'll go ahead and take a recess while Ms. Skinner reaches out to petitioner's counsel. So we'll go off the record.
Good morning. I apologize for being late. I was on the wrong link.
All right, we're going to go back on the record. Lincoln County Cause CV-2026-00191. Counsel, if you'll announce your appearances for the record. You're on mute.
Nelly Valencia for the petitioner.
Good morning, Judge Richard Bustamante, on behalf of respondents, the State of New Mexico Racing Commission, and the Board of Stewards of Rio Desert Downs.
All right, morning, counsel. We've got a bunch of motions to talk about that have been filed. There's the original petition where there's a request to extend that petition, and now there's a separate petition, supplemental petition related to the other two petitioners. There's also the request for an order to show cause. Is petitioners planning on presenting evidence, Ms. Valencia? Like witnesses' testimony?
Your Honor, we don't anticipate any testimony today.
Okay, Mr. Bustamante, did you anticipate any?
Judge, we do not anticipate providing any testimony here today. Thank you.
Only reason I'm asking is because I was going to put them in a breakout session and get them out of the meet since there's a number of people present. So, all right. Seems like everything's kind of intermingled. The order to show cause probably can be dealt with a little bit separately, but I suggest let's start with the request for the extension, since by its own terms the TRO entered by the court expires today, with the thought that there was going to be an evidentiary hearing. Have a conversation about that and the request on behalf of Mr. Valerio and Mr. Garcia to enter a restraining order at this point. Ms. Valencia?
Your Honor, first of all, we'd like to request that this hearing be recorded, and we'd like a copy of it.
It's being recorded. We're on the record. It's a district court record of record. My court monitor is making a recording, and you just need to file a request for a request for the video, the audio recording that's being made. But Ms. Madrano is my court monitor. She's on and she is recording.
Thank you, Your Honor. Your Honor, before we begin, the court's evidence procedures require the exhibits be submitted 48 hours in advance. That would have been 9 a.m. on Tuesday. The notice of hearing was issued on Tuesday at 9:53. I have submitted our exhibits and served them on Mr. Bustamante, and I ask leave to have them received. They're almost all the court's own order and respondents' own filings.
Bustamante, I'm not sure that we're going to need any of the exhibits, but in the event that they are requested to be entered, I mean, everything that's part of the district court file is already part of the record, but any objection to any of the proposed exhibits for the hearing?
No objection, Your Honor, especially considering that they are pretty much the court file. Thank you, sir.
Okay. All right, Ms. Valencia?
Yes, Your Honor. Excuse me. I'm just reviewing some of my notes. Thank you. Yes, Your Honor. First of all, I'd like to state that this court's order expires today, and we ask that it be extended or replaced with a preliminary injunction. Paragraph B of that order named 11 horses, 5 were entered and 6 were not. We ask the court to require respondents to answer for that. Number 3, respondents ask the court to clarify paragraph C. Paragraph C is a savings clause. We do not oppose the clarification. We oppose turning a limit on relief into a grant of authority. Number 4, Mr. Valerio and Mr. Garcia need protection in their own names. Mr. Valerio began working for Mr. Valeriano on April 30th. Mr. Garcia's license issued April 30th of this year. The conduct alleged occurred in 2024. Yes, so paragraph E says the order expires today. The court chose that date for the reason the findings say the injury was irreparable because of the summary suspension hearing was not until August 6th. The court tied the life of the order to that hearing. That hearing is happening this afternoon. I want to tell the court exactly what is happening. On Monday morning, Mr. Bustamante wrote that the commission needs 3 to 5 days to produce records. 3 days was today. On Tuesday afternoon, he produced 64 pages and called it, in his own words, a portion of the request. Yesterday at 3:09, he told the Board of Stewards in writing that production is, quote, ongoing. 41 minutes later, the board denied our motion to continue in 2 sentences without giving a reason. That is Exhibit A and Exhibit B to the notice of filing we filed. I have not characterized them, I've quoted them. So the administrative process that the court's order was meant to hold the line for begins at 1 o'clock today. And on record, the commission itself describes as incomplete. That is precisely why the status quo needs to be preserved a little while longer. On the rule, I want to be straight with the court. Rule 1-066B lets the court extend for good cause and for a like period. Beyond that, it takes respondents' consent, and I have asked for it 3 times without an answer. The cleaner course is a preliminary injunction. Rule 1-066A requires notice. Respondents have had notice since July 31st. They appeared on August 1st. They filed a response with an affidavit and exhibits on August 2nd. They filed a motion on their own. They have been heard. The court can enter preliminary injunction on the record in the same terms, and then no one is counting days. So, Your Honor, that's what I have at the moment.
Thank you. We're going to talk about the order shall cause separate and apart from the request for extension and the request on behalf of Mr. Valerio and Mr. Garcia. So, Mr. Bustamante, I guess let me start off with a couple of questions that maybe you can help clarify.
Yes, sir.
So some disclosures have been made. What disclosures have been made, and what disclosures are you anticipating still need to be made before the evidentiary hearing that's scheduled for this afternoon?
You know, Judge, Petitioner's Counsel submitted an IPA request in addition to a significant list of discovery requests. What has been provided so far is they've been provided the USDA report, which is referenced in the summary suspension rulings. We have provided some information relevant to match racing. We have provided the letter from the governor. We have provided, I believe we've provided also information regarding a series of horses that were trained by M. Heath Taylor when he was employed by Mr. Valeriano. And those horses basically had carmoterol positives, which is a illegal and illicit drug that has no use in horses. And also those horses got infected with EIA, which is a very contagious disease. They either died or had to be euthanized. After this hearing, we will provide essentially the exculpatory evidence of the ruling histories of the petitioners and everything else that we can gather. Admittedly, we have been working overtime to do this. It's very tough when Petitioners Counsel inundates us with emails which appear to be AI generated and are very, very difficult to keep up with. But the commission has exercised due diligence in basically gathering documents and proceeding to forward them to council. Just to let you know, Judge, briefly, discipline at the New Mexico Racing Commission has three elements. The first is a summary suspension, which basically the stewards can basically summarily suspend petitioner's license based on them being an immediate danger to the health, safety, welfare of the racing industry. This afternoon's hearings, which are taking place, are the summary suspension hearings. That simply, the lone issue there is whether the summary suspension should be continued. The final set of hearings is the disciplinary hearing, and that is when the petitioners will receive a notice of hearing that further details the specific allegations against them. By that time, they will have all of the relevant evidence and everything else they asked for. And then that is when the evidentiary hearing is held in full, where the stewards determine whether the commission has met its burden, and if so, what type of disciplinary sanctions, if any, they will submit to the petitioners. So again, this afternoon's hearings, the sole issue is whether the summary suspension should continue. It is not the full evidentiary hearing involving potential disciplinary consequences.
And Mr. Bustamante, at that hearing, the commission has a burden, correct?
The commission does have a burden, sir, basically to show by the preponderance of the evidence whether the petitioners still pose an immediate danger to the health, safety, and welfare of the industry. And Judge, very briefly, that's a common phrase. It is within our rules. Basically, it's broken down into two components. Health and safety of the horses, because those horses cannot speak for themselves, and therefore the commission does it for them with respect to medication positives or other conduct relevant to the horse. The second component is the health, safety, and welfare of the horse racing industry, and that basically extends to the fact that this is a sport where the public can wager, and the wagerers and the fans of the sport rely on basically the industry being run cleanly. The stewards keep doing their job to keep out cheaters and people who engage in conduct that is detrimental to the industry. And essentially, those are the elements that the commission will be addressing this afternoon. And again, that is not a full-blown evidentiary disciplinary hearing. It is just a hearing to show that based on the investigation as it's proceeding, the commission respectfully believes that these petitioners still are an immediate danger to the health, safety, and welfare of the industry.
You would agree that that hearing, though, there has to still be some basic due process rights that are ensured.
Yes, correct, Judge.
And so I guess two-part question here. The first is, has all of the information that the commission plans on introducing at that hearing been disclosed over to the or to the petitioners? And the second part would be, has other exculpatory information that the commission is aware of, has that been disclosed over to the petitioners?
The exculpatory evidence that we have will be produced to the Petitioners Council immediately after this hearing. And Judge, that consists of the ruling histories of each of the petitioners. Ruling history is basically exactly what it is. A ruling essentially is a written disciplinary action against a petitioner for whatever reason. And the comprehensive ruling history, I believe, entails not only New Mexico's activity, if any, against these individuals, but also if they've experienced a disciplinary action in any other proceedings. This afternoon, we will be focusing on the carmoterol positives, as well as potential involvement in match racing. Match racing basically is a practice where people gather for unlicensed, unregulated horse races. They just literally will set up a makeshift horse race track somewhere in the rural parts of the state and actually throughout the country. And those are a vector for a significant number of illegal activities. So those are the things that we will be focusing on. Also, Judge, just to let you know, part of the carmoterol positives also include the fact that those horses were also infected with EIA, equine immunity, equine infectious immunity, which is a highly contagious disease, no cure for. A horse infected either has to be sequestered for the rest of their lives or unfortunately euthanized. Those are the two matters that we will be focusing on this afternoon. And respectfully, we believe that we have provided the evidence relevant to that to Petitioners Council, and immediately after this hearing, we will provide additional evidence to that effect.
You have produced everything that the commission plans on introducing during the hearing this afternoon, though?
Judge, I respectfully believe so. We're getting evidence pretty much all the time, Judge. And for instance, we had to reach out to our vets for their evidence. I don't know if we've received that yet, but we are making every effort possible.
All right. And so let me just be clear why I entered the TRO, because it came in at 4:15 on Friday, and I had a criminal docket that lasted until 4:15. Got out, had about 30 minutes to review it before my clerks left for the day so that I could actually get something filed. So it was a quick decision, and the decision was primarily based on a due process issue. It's not the merits of the issue. I knew nothing about the merits. It's whether or not there was, enough due process afforded to the petitioners to potentially justify the summary suspension. And I found that the notice probably did not sufficiently advise them of what they exactly were being accused of. And so it seems like there's been a lot more detail about what the accusations are have been disclosed. If I look at the Berry versus Barkey U.S. Supreme Court case, 443 U.S. 55, which is obviously something that New Mexico focused in largely in the Yoakum case, 1991 NMCA 153. What I'm concerned about is the meaningful time seems like it's being met with a hearing this afternoon. The question is the hearing being conducted in a meaningful manner? And part of that means giving them an opportunity to be adequately prepared to meet the evidence and try to present evidence on their own behalfs to meet the allegations. And so I guess that's kind of where I want my focus to be on in this hearing and what my decision is going to be. Because ultimately, I'm going to tell you right now, I'm not going to get involved with the underlying hearing. There's a process for that. The only thing I'm trying to make sure is that due process rights are afforded. As long as due process is afforded, everything else can come back on appeal, administrative appeal at a later date. But I'm concerned with a couple of different parts about the summary suspension. Mr. Bustamante, what took so long? If these results were from something that happened in 2024, we're in August 2026. That's 2 years delay. What took so long for the Racing Commission to figure out this stuff has been going on, and why, I guess, was there a decision to wait an additional, I guess, 14 days before the stewards decided to move forward? Because that's part of my frustration when I issued the TROs. It seems like if on the 17th you issue these summary suspensions, this hearing already happens before any entries have to be made for the All-American, and we don't have the dispute that we're having. But by the lateness of waiting until July 30th, the day before the entries were due, it creates a massive problem. So if Mr. Bustamante, you can address those two issues with, number one, what took so long from 2024 to now to figure out that they were a danger that required summary suspension, and number two, why did the stewards sit on this for 14 days? Because it almost looks like, and I'm not saying that that was intentional, but it creates a perception that it was done intentionally to block them from these races without due process.
All right. Judge, thank you for those questions. And with respect to the first question about the delay regarding the timing of the carmodorol positives versus when the commission acted upon it, essentially, Judge, we did receive the USDA report approximately July 16th. And what the USDA report did for our investigators and the commission was essentially kind of tie all things together in terms of the connection of the trainer involved at that time, and obviously with respect to the owner of those horses, and it provided a level of information regarding perhaps greater involvement by the licensees, specifically Petitioner Valeriano and his then trainer, M. Heath Taylor. So that USDA report really kind of helped fill in a lot of gaps that the commission initially had. The other reason for the delay is that when those carmodorol positives were brought up, well, the commission instituted disciplinary action against trainer Mike Joyner, M. Heath Taylor, and another trainer who is not involved in this matter. Each licensee is entitled to what we call a split sample. The original samples are taken and tested, and then a portion of those original samples are set aside so that the licensee can then basically have that sample tested to see if a different result comes up than the commission's official sample. We have been in district court for over a year and a half, trying to basically get these split samples tested, but unfortunately, petitioners counsel, none of the petitioners here, but they are basically objecting to the one lab in the United States that will accept these and that can test to the limits. So we are literally, Judge, searching the entire world for additional labs that might be able to take this. So that explains the delay in terms of proceeding forward with those disciplinary matters that are, we believe, are connected to the summary suspensions involved here.
So when did the action against Mr. Taylor start?
The actions with Mr. Taylor commenced February 12th, 2025. And we have been in district court still on the issue of the split samples since probably mid 2025, and the issue is still not resolved regarding. We want to provide them their split sample rights. They just will not agree to the lab that is willing to accept them in the United States. Regarding your second question, Your Honor, with respect to the delay, we did receive that USDA report on July 16th, I believe, and it was submitted to the stewards. Judge, when the stewards received it, they are currently in the process of managing a live race meet. That would be the Ruidoso Downs live race meet that is being held at the Downs of Albuquerque. And so, Judge, they are obviously having to watch over live races and make decisions. as well as conduct disciplinary hearings, deal with issues, administrative issues with the track and licensees. So they did not sit on the report. It was just a matter of they have so much duties to do, basically, that, basically the stewards act independently, and essentially they acted when they did just based on their busy schedules. In other words, the press of business basically impacted the steward's ability to really digest that report and then determine that an investigation need to happen, and for the safety of the horses and the wagering public and the fans of the sport, the summary suspension rulings went out in order to basically put these petitioners, kind of put their licenses on freeze in order to allow the investigation to continue, and then see if it eventually leads to disciplinary measures after the disciplinary hearing.
So I guess the question is, what did the USDA report provide that wasn't already known in the Taylor case? I guess I'm trying to understand what made the link more probable that an owner involvement was involved through the USDA report.
Well, Judge, you essentially exactly stated what I was just going to say. What the USDA report provided the commission, that before it was lacking, was a possible connection actually between petitioner owner Mr. Valeriano and his then trainer Heath Taylor regarding a potential lack or potential knowledge, if not involvement in possible illegal use of carmoterol in the horses, which what the USDA report provides is that with the injection of carmoterol into the horses, that essentially is what caused the EIA transmission among the horses. Unfortunately, the same needle was used, basically put into the same bottle, and then injected in multiple horses. And of course, then blood basically got transmitted between horses, and that spread the EIA infection. So the USDA report really kind of put that tie together such that the commission could investigate further. Also, what the USDA report provided was more information and specific information regarding Petitioner Valeriano, my apologies, sir, involvement in match racing. Again, match racing is unsanctioned racing, done all around the country, completely unregulated. And so those are the two areas that the USDA report really provided further information and ties, such that the stewards felt and determined that these gentlemen were an immediate danger to the health safety of the racing industry, and which led to the summary suspension. And the commission started investigating this matter after that USDA report, essentially the next day, July 17th. And of course, that investigation is ongoing.
I guess to separate it out, because there's different petitioners here, then you've got Mr. Valerio and Mr. Garcia. And I guess I've heard a lot about how Mr. Valeriano might be involved, but I haven't heard anything about Mr. Valerio or Mr. Garcia and why there was a decision to do a summary suspension on those two after this long process involving Mr. Taylor started in 2025.
And Judge, basically with the, obviously Mr. Valerio and Mr. Garcia are employed, are under the employ of the trainer, Valerio. And essentially so therefore they're under, they train and work with some of Petitioner Valeriano's horses. And therefore, out of concern for, after we received information from the USDA report regarding how they transmitted this drug, we were concerned about both the trainer and owner's involvement in this. And then also,
That was Mr. Taylor, right? The horses that are issued, that was Mr. Taylor who was training the horses at that time.
that was Mr. Trainer, yes. The USDA report also provided information tying Petitioner Garcia to several trainers, basically regarding carmoterol positives. So just given the information that connected Petitioner Garcia to other trainers and possible carmoterol positives, we were concerned about the ties there. And of course, obviously we know that the horses involved in the USDA report were with another trainer. However, the connective tissue throughout is Petitioner Valeriano as owner.
I don't know.
Let me clarify, Judge, for the record, the USDA report does not list Petitioner Garcia by name. So I just wanted to make that clear for the record, sir.
So it's other evidence that the commission believes it has that ties Mr. Garcia to other horses that have had issues?
Yes.
Right.
Other trainers, yes.
All right, so I'm ignorant when it comes to horse racing. I played hooky a few days with my grandfather when I was little and went to the Downs of Albuquerque a few times, but I don't know much about horse racing. But I do understand that I think this is a 2-year-old race. And once they're not 2, they don't get to do it. And there's quite a bit of money that's at risk. And so I'm going to go back to the Berry versus Barkey case and the requests related to irreparable harm or substantial harm. And, you know, this is the concurring opinion, so obviously not the controlling one, but I felt this was somewhat persuasive, talking about the potential injuries that are going to occur. It says, whereas here, even a short temporary suspension threatens to inflict substantial and irreparable harm, an initial deprivation quickly becomes final, and the procedures afforded either before or immediately after suspension are de facto the final procedures. A final full hearing and determination after Barkey had been barred from racing his horses and had lost his clients to other trainers was aptly described by the district court as an exercise in futility. It would certainly not qualify as a meaningful opportunity to be heard at a meaningful time. And I think that that's part of my issue with how the case was brought. And I understand that the press of business is what is, they're busy, I get it. But we're taking a substantial risk for Mr. Valerio, Mr. Garcia, Mr. Valeriano. They've invested a lot of money. If the commission is wrong, what's their remedy, Mr. Bustamante? How do they fix this situation? Because they're not going to be able to prove that their horses would have won. They're not going to be able to establish those damages, practically speaking. So I guess that's my concern, is if there's still information that's flooding in now, not giving them the continuance so that they can process it and prepare for a cross-examination and presentation of evidence before this post-suspension kind of temporary preponderance probable cause, should the suspension stay in place. How are we adequately protecting their constitutional rights if we're throwing all of this information, given the consequence is so severe? And why would the commission not just give them a day or two until all of the evidence was in to prepare and then move forward with the hearing?
Okay. And Judge, thank you for that question. And just to backtrack a little, you hit the nail right on the head, Judge, is that regarding the question of a potential injury here or potential losses. Judge, just like you said, just because a licensee is allowed to enter in a race does not mean that that horse is necessarily going to run in that race. It could be scratched for other reasons. If it runs, it does not mean that essentially it will finish in place such that it will win the race or secure any purse. So essentially that is all speculation and conjecture regarding the potential injury to these individuals. Furthermore, Judge, case law is well established and even specific to racing licenses. Licensure by the New Mexico Racing Commission is not a right, it's a privilege. Moreover, because there's no guarantee of entry in a race, means running and winning, there are no property rights and potential purse money involved. The other thing that the commission looks at, especially the Board of Stewards, is essentially the idea of allowing these horses to run. Well, then potentially these horses might be subjected to injury If unfortunately efforts are going to continue, and unfortunately we see this a scourge in the industry of essentially drugging horses that are totally dependent on the care of their trainers and owners simply to gain a competitive advantage. So essentially, given the speculative nature of the injuries here, and out of concern, one other element, sir, is the betting public and the fans of the sport rely on certainty regarding these races. Certainty in terms of who's entered in these races, the fact that the final fields for those entries have already been set for the time trials, and that information has been disseminated such that the betting public and the wagering fan can review that and then consider for themselves regarding their participation in the races by wagering or just being in the stands cheering them on. So the commission believes, with all due respect, that out of concern for the safety of the horses, out of concern for the wagering fans and the public, and given the speculative nature of quote unquote damages here, that we feel basically that the summary suspension process should proceed, and then the disciplinary process should proceed thereafter.
So I'm not necessarily disagreeing that the state's interest is high, and I think that's essentially what you're arguing. But I think when the state's interest is high, it also creates a burden on the commission, and that is to make sure that there are, I'll give you an example in the criminal context, just because I think it's what I'm more familiar with and a little bit illustrative of what I mean. So say someone goes out and they believe that the state believes they've committed a homicide. Under our Constitution and our due process laws, the state wants to detain that individual. They have to have to file a motion to hold the offender and prove by clear and convincing evidence certain standards. That creates a burden on the state. Once they're held, they got to get a probable cause determination within 10 business days, similar to the hearing within 10 days here. And they also have to have this clear and convincing showing. And so they have to produce all of the evidence. And what I'm concerned about is that it sounds like the commission is still receiving evidence that hasn't been disclosed to the petitioners. And I don't know how you have a meaningful opportunity to meet the allegations, because that's what's required, right? It's not just a meaningful time, it has to be in a meaningful manner. And that's the part that I'm struggling with. I agree that the state's interest is high. What I'm struggling with is when the state's interest is high, if the state wants to protect that interest, they have an obligation to move quickly too. And the press of business isn't an excuse for not being able to meet that standard. And so if you're going to do this and you have the report on the 16th and you're going to do a summary suspension, you got to be moving fast, because you're going to know that I'm going to have this hearing within 10 days. I'm going to need to present this evidence. The petitioners have the right to confront it. They have a right to cross-examine witnesses, present evidence on their own behalf. This is on your own rules, not me making this up. This is your own administrative rules of what due process means. And so why has it taken so long to collect this evidence together to produce for them for the hearing for this afternoon?
And Judge, essentially, all of this, it seems like much longer, but basically all of this just started on essentially late Friday afternoon, basically. And here we are Thursday. So the commission staff is small and scattered in the sense of we have vets that work in various parts of the state. And so we have been working feverishly to try to essentially obtain all the information that perhaps the vets may have in order to provide it. And that is a continuing process. Again, given that the summary suspension hearings this afternoon, the sole issue is whether these individuals continue to pose an immediate danger to the health, safety, and welfare of the industry. The commission respectfully submits that the information that we have received, provided so far, as well as the information we're going to provide immediately after this hearing, will provide the petitioners with a sufficient basis on which basically they can argue against the commission's bases for requesting that the summary suspension should continue. Judge, I just do want to let you know, as an officer of the court and in full candor, that under the commission's rules, a summary suspension has two impacts on the licensee. Generally, it impacts their ability to use a license. But with respect to a trainer and owner, a summary suspension basically impacts their ability to enter a race. They cannot enter unless, of course, for example, responding to the judge's TRO. So that's how they were allowed to enter, because of the TRO, which the commission followed and we'll discuss later. The second impact of a summary suspension on a trainer and owner is their ability to be able to actually run in a race. So I just wanted to bring that in full candor to the judge's attention, because the TRO as listed or as written deals with the petitioner's ability to enter in a race.
I agree, and that was intentional. I don't think that because the hearing was supposed to occur today, and it still might, and that would be subject to different petition and different considerations. And I guess what I want to reemphasize is that the only reason the TRO was even entered was the due process issue. It had nothing to do with the merits of the actions or anything like that. It was just a concern about the due process part. Ms. Valencia, we've had a lot of conversations, so I want to give you an opportunity to respond to Mr. Bustamante's comments and add whatever you want for the record. You're on mute. Ms. Valencia, you're on mute. We can't hear you.
Yes, thank you, Your Honor. I appreciate the opportunity to speak. Again, we don't want to interfere with the steward's hearings. We want to be able to file another TRO if needed, because we do believe that this is a violation of due process. Being that Mr. Bustamante, like he mentioned, he is still ongoing, sending us new information that we can't adequately analyze because of the short-term notice. He's telling the court right now that he's going to provide information to us after the hearing, but the hearing that is scheduled for 1 o'clock, it's a very short time frame from when he's going to provide the information. So that would be a violation of due process. Also, and just the delay in providing us with information. Your Honor, at 7:37 this morning, the respondents produced the governor's letter that was dated July 21st. So if they've had it since then, why wasn't it produced? So the commission had the USDA report also on July 10th, and the press published it on July 15th. The governor wrote on July 21st asking for an investigation into all trainers, owners, and agents, and for the suspension or revocation. 9 days later, the commission suspended an owner, a trainer, and a groom. Again, the governor did nothing improper. The governor may write to her own agency, and this letter reads as a legitimate expression of concern about horse safety. But the commission must show immediate danger. The conduct was in 2024. Every horse in that outbreak is dead. Their executive director was receiving USDA updates in October 2024. They held a press conference in February of 2025 and suspended the trainer the same day. Nothing about the danger changed between February 2025 and July 30th, 2026. What changed is dated July 21st, 2026, and they did not produce that until this morning. And while we've been in this hearing at 9:04 a.m., we received other supplemental evidence, which obviously I can't review because we're in this hearing. So again, there's lack of time there. I also would object to the statement that Mr. Bustamante made regarding our emails and other communication being AI generated. That is not the case whatsoever. So I would like to make that for the record. And also, Your Honor, these allegations, because they occurred in 2024, there's no immediate harm, but not only that, there has been no other action since. If there's been ongoing investigation since that time frame, no others have been brought to our attention. So for that reason, we would like you to consider those facts.
On your original petition, you were asking for a stay until you could get the due process hearing. Now you've got the due process hearing, but you're wanting to continue it. I understand that disclosures are coming fast and furious, but you can't in one hand argue for a quick hearing and then also complain that you don't have time to prepare. They're counter arguments. And so I guess you're going to have to pick. Do you want more time to prepare for the hearing and your guys stay suspended for a little bit longer? Or do you want to have the hearing quickly so that you have that due process opportunity to confront the evidence and go to the hearing, Mr. Valencia? And I guess that's my struggle when you're asking me to extend a TRO or inter preliminary injunction. I do think that there is a point in time, like, you know, it doesn't matter whether I'm looking at the unpublished opinion of Hernandez versus the commission or anything else. Rule 75 really should be dictating what I get involved with. The only reason I allowed Rule 66 to apply in this instance is because of the constitutional violations, not because of the process that was done at the commission. And that's where I'm struggling with your argument, is that you've asked for a remedy, and I'm going to talk to Mr. Bustamante in the order to show cause of what I think the remedy needs to be to deal with the horses that were not entered in the futurity race. We'll talk about that next. But the real request, and the only reason I entered this order, was because I felt like there was a due process violation. So tell me how your client's due process violations are still occurring if the commission is saying, we're going to give you that hearing. You can now confront the evidence and you can present your own evidence as to why the stewards were wrong. And you have that opportunity to present and confront evidence. So why would that be a violation to now allow that hearing to take place and for me to step out and allow the commission to do what they're permitted to do under the rules and statutes of the state of New Mexico?
Your Honor, we would like the opportunity to prepare for the hearing and not rush it.
But you can't, but you understand part of the summary suspension and the due process rights requires the rush. And so you can't both say my clients are not being afforded due process because they're not being given a hearing and an opportunity to confront the evidence against them and to present their own evidence, but at the same time say, now continue that hearing. You got to choose, right? I mean, and it happens every day in courts where, I use a criminal proceeding, but I'll give you another one that is subject to 10-day. Well, we issue TROs or firearm restrictions on people all the time without them having notice, right? Like if someone files a petition under the Family Violence Protection Act and they want a protective order against a household member who's committed domestic violence, we set that hearing within 10 days, period, because we're restraining that person's constitutional liberties. We're not letting them go to their house sometimes, not go to their job. They can't have firearms. There's all kinds of restrictions. Within 10 days, they get that hearing. If they want a continuance within the 10 days, what happens? The order gets extended. The suspension gets extended until you have more time. And so it's one of those choices that the petitioners need to decide. Are you willing to be summarily suspended and have the hearing delayed, which it sounds like in this process would really just kind of be a consent to the preponderance of the evidence of the summary suspension until the full hearing can be had. Is that your preference, or do you want to have a quick hearing this afternoon so that you can confront it and try to get this summary suspension lifted? Because you can't have both.
I understand, Your Honor. If I can just have a moment to confer with my clients to see what their preference would be, and that way I can adequately present to the court.
Sure, I can put you in a breakout session if you'd like, or if you want to have your clients log off and call you and you go log back on, I can take a 10-minute recess. Up to you.
Yes, Your Honor. We
How do
would
you want to do it?
appreciate it. Log off and have them log back in.
Okay, so why don't you get a conference call? We're going to take a 10-minute recess, so we'll reconvene at 10 a.m. We'll go off the record.
Yes,
Thank
thank
you.
you, Your Honor.
Thank you, Judge.
All right. Ms. Valencia, are you ready to go? All right, we're going to go back on the record in Lincoln County Count CV 2026-191, Valeriano et al. Versus New Mexico Racing Commission et al. Ms. Valencia, you had an opportunity to consult with your clients. Go ahead and proceed.
Yes, Your Honor. Thank you so much. We appreciate that opportunity. Your Honor, we would like to move forward with the suspension hearing today. Even though we do not consent to being suspended if that's the outcome. Your Honor, the rules regarding suspension require admissible evidence to substantiate the suspension, and it can't be on hearsay alone. So I would like to ask Mr. Bustamante now in open court, what evidence does he have that is not hearsay?
Well, what I'm going to do is this. I don't have any control over how the hearing is going to be conducted. I think that would be an advisory opinion. And so I think that would be outside the scope of what I have jurisdiction for. I will say this, Mr. Bustamante, it's not so much an advisory opinion. I think that there's very common principles of due process, and part of those have to do with the disclosures that we've talked about, including giving any exculpatory information that may exist, and you've told me that you've complied with that and you believe that most of the evidence has been produced. I think it would be an error that might cost the commission in the future if a bunch of evidence is produced that was never produced to the petitioners at that hearing. But just comply with due process, follow your rules, because the case law is pretty clear that if you don't, you're going to probably see me or another judge pretty soon and have to deal with that consequence. So it sounds like the hearing's going to go forward, so that I think will probably eliminate the need for me to continue or enter any additional restraining orders. So let's focus now, turn our attention to the order show cause and whether or not there should be any consequence related to. And I guess to kind of fast forward, I've read your all's briefing. I understand what occurred and I understand what the positions are. So just kind of focus in on what you think the proper remedies would be, if there should be any remedy. And I understand, Ms. Valencia, you're asking for certain damages as well, but I'll let you make those arguments as well. So we'll start with petitioners.
Yes, Your Honor. So just to clarify that nothing we seek is punitive. The coercive part is purgeable at the moment the 6 horses are entered. The compensatory part is the expense of bringing the motion. But Mr. Bustamante cites Corliss for the proposition that contempt power is used cautiously and sparingly. I agree with him. That's why the relief ends at the moment that they would comply. So again, we're not asking to scrap the July 31st entries. We're not asking that any horse be scratched. Their warning about the 280 owners and the trainers answers an argument that nobody made. We only asked to be added, and by the same mechanism that their own witnesses describe.
I'm going to ask you some technical questions about racing because I just don't understand it. And if you don't know, I'll go to Mr. Bustamante as well. So my understanding is that there are time trials and there's just races. The races occur like any other race. I'm a football guy. I guess this would be the playoffs, and you got to win the playoffs before you get to play in the Super Bowl, kind of sort of situation. But that's my understanding of how these trials work. You got to get a certain time, and regardless of what race you're in, if you make the certain time, you're going to get to be in the big dance and the big race for $1 million or whatever it is this year. Is there an opportunity at this stage, I guess, Mr. Bustamante, to add the 5 or 6 horses that were left off on the trials, and how would that occur? I understand procedurally that you're saying that perhaps other parties should have been joined to this lawsuit. I want you to skip that part of your argument. Just practically speaking, could you run a trial with just these 6 horses? And is it just the timing of what they run in their race, regardless of who they're opposing, or is it the winners of these races? That's the part I don't understand. Is it like they've got to get like a certain time, or do they have to win the race before they advance?
You know, Judge, basically they are time trials. So basically what the whoever makes it to the finals, it's based on their timing regarding how they ran in that race, in the trial race. So the top time finishers will basically advance to the final race.
Let's say there's 6 different trials and the top 5 horses come from the same trial. Those top 5 horses are going to make it regardless of where they place in that individual race, correct?
It is all based on the times, yeah. So in other words, there'll be, for instance, in the races that where the entries closed on July 31st, hours before the TRO order, those fields have already been set for the time trials. So 280 horses were entered. Then what happened is the racing office at the Downs, starting, I believe, that very afternoon and continuing into Saturday, they set the fields for all of the trial races.
How is that done?
Excuse me?
How is that part done? Is it like a random draw of who runs against 2, or is it based on like seedings, based on people, how they've been racing all year?
It is a double blind draw. So it's completely random, basically, in terms of here's 280 entries, a double blind draw, and then they set the fields. So typically those fields will have 9 to 10 horses each. And so they're for the time trials for the All-American Quarter Horse Futurity, which those entries closed on the morning of July 31st. There's going to be 9 or 10 races, basically, of time trials. The top time finishers essentially advance to the finals. Now, regarding your question about, well, couldn't you just add another race and have Petitioner Valeriano's horses run in that race? Well, there's several problems with that. First of all, once the Downs of Albuquerque Racing Office set those time trials, essentially they finalized them and they disseminated that information. So that information is already publicly available for the fans and wagers of the sport to see and then determine, hey, look at the odds of this horse, maybe I'll bet here. So the public is already relying on those time trials. And it is a total of 14 races that will take place to determine the final runners in the All-American Quarter Horse Finals. Now, here's the difficulty, Judge, of essentially tacking on another race just to allow Mr. Valeriano's horses to run. First of all, again, that information has already been disseminated that for the American Quarter Horse Futurity, there are going to be 14 time trial races in order to determine what the final field is for the finals. Bottom line is there is a difference in running a race when you've got 9 or 10 horses all barreling down the racetrack, desperately trying to get that best time, versus another race where there's only 6 horses running. There's more room on the track. And so basically when you tack on an additional race, one, essentially the betting public has already received information on who the finalists are. And then all of a sudden they find out, oh, we have 6 more horses. Then, of course, there is the very real advantage that Mr. Valeriano's horses will have when they're running in a time trial, 6 horses as compared to 9 or 10. So there is the very real potential that Mr. Valeriano's horses will have an unfair advantage in those time trials. Why? Because there's just more room on that track and less jockeying among 9 or 10 horses, jockeying for those sweet spots and running desperately to try to get the best time in order to make the finals. So that is problematic. Then
what happens when the horses get scratched though, right? Like you told me that horses get scratched all the time. Let's say 9 horses are scheduled, 3 of them get scratched right before the race. Those 6 are still going to run that race, aren't they?
Yes, Judge, that does happen. And of course, that's just the reality of how things can happen literally at the last second in these races. Oh, yeah. And obviously, if horses are scratched, they're not competing in the time trials.
No, I know, but you're talking about the competitive advantage of having fewer horses. That can happen naturally anyways.
Correct, sir. But again, the idea is that they go in there with, a field of 9 or 10 horses. Obviously, Judge, they are wild animals, so anything can happen. Trainers and owners can choose to scratch their horses for whatever reason. Maybe the horse isn't doing well. Maybe it got injured, things of that nature. The stewards can scratch horses. For example, sometimes the horse will rear up in the starting gate significantly, throw the jockey off. And then there are concerns of what is wrong with that horse? Is it okay? Has it been improperly medicated? So the stewards can basically scratch that. But again, all of these things happen very close in time to that starting gate opening and the horses barreling down that track. That is in contrast to if another race is tacked on to the All-American Trials, where it starts, where the field is 6 horses that have much more room to run, and much more room to jockey for the sweet spots in order to get those best times. So it really does put Mr. Valeriano's horses in an unfair competitive advantage in terms of getting the best times in order to make the final races.
And I guess, and I'm not trying to skip on you, Ms. Valencia. I'm gonna come back to in here for you. But part of my heartache with your argument, Mr. Bustamante, is due to the timing of which the stewards are the ones that chose, due to the timing on how this all occurred. How could they have made their entries? And I guess kind of bleeding into that question, how do you differentiate their attempts to enter their horses by Mr. Valerio's son, Ryan Valerio, who submitted the affidavit? How's that different than any other attempts that were maybe forestalled and done later in the day? I get that it's common practice because you need a vet to clear a horse or something like that. In this instance, there was an attempt to register these horses or enter these horses, and that attempt was rebuffed by the stewards and the secretary, and it was done so because of an action that I enjoined. And so I guess the question is if the commission created, or arguably the commission's agents created this scenario, how am I supposed to just say, oh, you guys are just out of luck? They timed it just right so that they got to deprive you of due process. Let's say they all prevail this afternoon, because presumably they have a fair chance. Otherwise, it's futile, and I should just enjoin you from suspending them altogether. Let's say they all prevail today. They've already been injured at this point because these 6 horses have been excluded, all based on the actions of these stewards, which was enjoined. And so how do I remedy that unless I order that you all allow the entries and then allow the scratch if they end up not prevailing later today?
Well, Judge, keep in mind, Judge, that 280 owners and trainers successfully entered their horses on the morning of July 31st. Why? Because essentially their licenses were clear. There was no summary suspension holds on their licenses. In other words, they basically had presented nothing to the stewards or the investigators or to the track indicating that any of those licensees were in immediate danger to the health, safety, and welfare of the industry. So basically, when anybody connected to Petitioner Valeriano attempted to enter that horse for the All-American Quarter Horse Futurity, rightfully they were turned away. Why? Because essentially his license was summarily suspended.
But that presumes the result, though, Mr. Bustamante. I guess let's say you have stewards that are racist for some reason, and they don't like African Americans, and there's an African American owner, and they decide to just do a summary suspension that's ultimately frivolous. What you're telling me is that they could do it in a manner that bars them from getting entered into the race if they time it correctly, even if their actions were completely unlawful and unethical, and there's no remedy for it, and we should just let it go because they happen to get this slap of a summary suspension. You're assuming the end result was that this was a justified summary suspension, and that's what you're having a hearing on. And I guess that's my heartache, is that you're barring them from a race that ultimately, I don't know what the prize is, but I know that it's reached $2 million if you win the whole thing before. you're barring them from that chance without any due process, without any opportunity. That's why the entry was so important, right? To get the entries in and allow them to be entered, and then you could scratch them all, just like you would have to with any other reason that happened. And that's why I'm struggling, because before you drew those races, the 280, there was still an opportunity to enter those 6 horses. You could have done it late. And before they were all dispersed out and said, these are going to be the races, all of these 6 horses could have been inserted. They all could have been scratched if you summarily end up suspending these folks at the end of their due process hearing, and nobody has any issues. But it was the actions of your agents that barred them from the entry. And now what you're just telling me is tough luck. They had this summary suspension. I'm not buying that part. I'm having a real struggle with that part, because you created this issue.
Well, and Judge, I understand your concerns, but essentially the rules are there, specifically the summary suspension rules, and the impacts of that on an individual's license. Again, it's there for the protection of the horse and protection of the betting public and fans. So the idea of when entries are open, basically, it is advertised as to when they close. There needs to be certainty to all the competitors in that enter in that race, as well as the fans and betting public, that when those entries closed, they are closed.
But that's not the case, Mr. Bustamante, because you guys allow for exceptions to that rule. For instance, if there is a need to get a clearance from a vet, or if you need paperwork related to an owner, which is
right,
that Mr. I can't remember. Was it Mr. Montez? Mr. Montez
Yeah.
attested to. Those types of exceptions do occur, and so I guess that's you're saying that there's this bright line, but there's not a bright line. There is some gray.
But respectfully, Judge, here is the difference. For example, Revolutionary V, which was one of Mr. Valeriano's horses, which was entered on Sunday. And here's the difference. When a trainer starts the entry process during the time that the entries are open, but then learns that there is some hold on the horse, perhaps even from an out-of-state racing jurisdiction, that allows them to complete that entry, or for the racing office to accept it as valid and complete. In that instance, the racing office can agree to hold the entries open in order to allow that trainer a time to basically correct those things, such that anything that is preventing that entry from being completed is taken care of and completed. So on the American Quarter Horse Futurity entries, morning of July 31st, they were open. There were 2 horses that faced that similar situation. They started that entry during the time the entries were open, and because they needed to clear up some things, the entries were held open until they could complete that stuff, and then they were entered. So that's a very important distinction, Judge.
But let's pause there for a second, Mr. Bustamante, because I agree that there is a distinction there. But now take in Mr. Valerio's attempts to also enter those 6 horses, because that's what happened. So what you're telling me is that there are instances in which, within the time frame in which there are trainers are able to enter the horses into these races, there are sometimes hiccups that occur, issues that occur that prevent them from fully getting them entered, and the commission will work with them to finalize and allow them to enter, even though there's this hiccup that exists. Mr. Valerio attempted to enter all 6 of these horses. He was just told, because he was suspended, he wasn't allowed to do so. And he wasn't allowed to do it himself because he was barred from the grounds based on that summary suspension. So he sent his son. And so his son kept asking, is my dad going to be able to enter these horses? And he was repeatedly told no. And so how do we prevent the arbitrary, capricious nature of a steward deciding to summarily suspend someone the day before entries start and end? I mean, you could imagine a situation in which very easily where a steward or a group of stewards could summarily suspend a trainer or an owner simply because they don't like that person. And if they time it correctly, they could rob them from the opportunity for the entire lifetime of that horse to win this particular racing series. And that's what's so troublesome to me, is that before, if Mr. Valerio does not attempt to enter the horses, I'm 100% on board with your argument. But he did try. And the only thing that prevented him to do so is the summary suspension. And the summary suspension was questionable and enjoined by this court because of a lack of due process. And so if I'm finding that to be an unlawful act, why would the commission not fix that before you drew the races and then scratch them if ultimately there was an opportunity to have that due process hearing before the race actually was run?
Okay. Well, Judge, first of all, you know, when Mr. Valeriano's son, basically, in other words, he could not enter those horses. Why? Because essentially the trainer was summarily suspended. So in other words, Judge, when Mr. Valeriano's son went to go try to enter those horses on the morning of July 31st, the racing office, oh, well, the trainer's license is suspended, therefore you cannot enter. In other words, what happened, Judge, is that the summary suspension and the impact of that license, the rules worked. There is something, the stewards are concerned about that you are in immediate danger to the health, safety, and welfare of the industry. Therefore, you are summarily suspended, and therefore you cannot enter, basically. So in other words, the racing office applied the rules as written. Now, the summary suspension process, again, Judge, the discipline in front of the stewards is a three-part process. Summary suspension, meaning that essentially we need to take this action because we feel there's an immediate danger to the health, safety, and welfare of the industry. That is done, and then immediately thereafter, within 10 days, they get a summary suspension hearing and then the final disciplinary hearing. So in other words, summary suspension is taken as a remedial, immediate emergency measure in order to basically the safety of the horses, to provide certainty to the betting public and the fans of the industry. So I know it's harsh, Judge, but basically the rules exist for a reason. Again, protection.
But what if the rules are enforced arbitrarily? Does that not violate due process? It's not so much, I'm not contesting that the rules exist for a reason or that the rules are invalid. But what I'm talking about is when you have a situation where stewards are exercising the authority under those rules in an arbitrary, capricious manner that violates due process, and that they choose to essentially exclude people from races in a way. I mean, the timing is very suspicious. If you're trying to tell me that the stewards decided to act on the 30th instead of August 1st or 2nd or the 3rd, I just don't believe you. They wanted to bar them from being able to enter these races. That's why they acted on the 30th. And they could have acted before, which would have given the due process hearing before so that they could have appealed and had that determination and still had the opportunity to enter if they prevailed at that due process hearing. Or they could have done it afterwards and they could have scratched the horses before the race was run. But they chose a specific date and time. And if it's an arbitrary decision from the stewards and an attempt to bar these folks from basically not being able to enter without any due process, that is something that can be enjoined by the court. And that's why I enjoined the action, because it appears from the surface that the timing of this was very suspect, that it was picked in a manner that would exclude these horses regardless of whether or not the commission would prevail on the hearing. And then that questions the futility of whether there's a futility argument, whether the due process hearing that's going to happen this afternoon is just going through the motions, or if it's an actual hearing where they're actually going to have the opportunity to present evidence and be heard in a real way. Because otherwise you're doing all of the damage intentionally up front, regardless of what the outcome of the due process hearing is. And that's why I'm really struggling with what the commission has done and its agents have done in this instance, is that this could have been handled in a much different way that would have avoided all of this. I would not have, if this had happened either before or after and it didn't preclude the entries or the opportunity to race after a due process hearing, I'm fine with it. But you're talking about millions of dollars and huge investments in these animals. I mean, you called them wild before. I think that the trainers probably would say they might have a streak of wild, but they're very domesticated. They're very trained. There's thousands of hours that goes into training these horses, ton of investment. And so you're going to give the authority and power to to a couple of stewards or a few stewards to be able to just make an arbitrary decision to choose the timing, because that's the one thing the stewards absolutely control. It's the timing of when they did the summary suspension. And that's what is so frustrating for me is, why choose this other than to exclude, so that regardless of what happens in this due process hearing, you've excluded these people from racing in the biggest races of the year with these horses.
And Judge, with all due respect, the decision of the stewards, essentially there's no evidence nor were their decisions arbitrary and capricious. As I noted earlier for the court, the stewards basically are involved in a live race meet. And obviously when they when they made the decision to summarily suspend, they were, of course, overseeing a live race meet. Their days.
What you're arguing, Mr. Bustamante, is that it was so critical, summary suspension, because there was an immediate danger. The word immediate means immediate, right? It doesn't mean 14 days. So they allowed the immediate danger to go for 14 days. Now it's no longer immediate, is it? I mean, if you think of that in any other context of the law, and you tell me that there's an immediate need to move, and you wait 14 days to move, you're never going to win that argument that it was an immediate an immediate need to do something. In any context of the law, you wait 14 days, it's not immediate anymore. That's what Ms. Valencia was arguing in her petition of, there's something different between choosing to, and I get the press of business. I'm not blaming the stewards or saying, I'm not even saying that these stewards intentionally did what I'm saying. I'm saying the process can be abused in a way. I'm not making that judgment. I want to make that clear. I'm not saying that the stewards intentionally did this to bar these people. Not what I'm saying. I'm saying that's what creates the appearance, because you're saying that there's an immediate need to suspend them. Then there's waiting 14 days. That does not mean immediate danger. Immediate danger means you get that report and, oh crap, there's an immediate danger. We got to protect these animals, and we got to protect the sport. Let's act. When you wait those 14 days, and it just happens to be right before the entries are for the biggest race of the season, that's my trouble. That's my issue. And I understand what your argument is. I guess the question is, how do we fix that if I decide that that I should hold people in civil contempt? How do I purge that contempt?
Well, Judge, I mean, you made reference earlier as to the and I apologize if you didn't use the word, about the fairness of that the summary suspension happens when it happened, and then the next day these rulings, these entries happen, and you talked about the fairness of that. Well, Judge, respectfully, I would ask the court to look at if Mr. Valeriano is able to enter these horses days past the entries already have been closed, days after the final fields have already been created and that information disseminated. Well, essentially what happens is that now you have 280 owners and trainers who are basically, the fairness to them basically takes a hit, as well as to the larger public in terms of the wagering fans and the betting public.
But Mr. Bustamante, who created that problem? Was that the commissions and their agents' actions, or was that the petitioners' actions? That was the commission, right? That was the stewards that decided to wait until they did. And I agree with what you're saying. I understand that there might be some prejudice, but any of that prejudice was created not by the petitioners. And so why should they be punished by an action that was done by the stewards?
And Judge, respectfully, the stewards did not create the problem. The stewards applied the rules as written and determined that they needed to immediately summarily suspend in order for the protection of the horses and protection of the betting public. So respectfully, I would argue that it was the petitioner Valeriano who created the problem, basically based on the information and the investigation that resulted from the USDA report. The stewards, once they received that, once they had an opportunity to digest it and discuss regarding how they should respond to that, and again, keep in mind, this is during a very busy live race meet, then they basically, what did they do? They decided to basically simply apply the rules as written in order for the protection of the horses and the betting public. So essentially, the stewards didn't create the situation. They essentially applied the rules as written And then obviously there are consequences from that. And Judge, just to let you know, these types of situations do occur, whether it's a huge race with a lot of public attention, a lot of dollars involved, but also basically for your average run-of-the-mill race. Again, the guiding force with the stewards is application of the rules as written, and those rules have consequences, and the basis for those rules is the protection of the betting public and the fans of the sport, and most importantly, the betting or the protection of the horses. So essentially, Judge, I would argue that where's the fairness of basically impacting the 280 owners that had clear, clean licenses, played by the rules, entered in a timely fashion? The betting public is already relying on those. The races have already been drawn, versus you give somebody the opportunity who rightfully was summarily suspended and will have the opportunity to fight that suspension as well as potential disciplinary process. Why create an exception for them to allow them to be entered days later after the races have already been drawn? And again, Judge, I will note that neither Rio Doso Downs or the Downs of Albuquerque are parties to this action.
Can they run a race without the commission? Can the Downs of Albuquerque or the Rio Doso Downs run a race without the commission's consent?
I'm sorry, what was that again, Judge?
Can the Downs of Albuquerque or the Rio Doso Downs, can they run races without the consent of the racing commission?
You know, Judge, the Racing Commission does award race days, and by statute, they have to have a minimum of 17 live race days in order to be able to have a casino that feeds the purses. Then they have to have, I believe, depending on the track, they have to run a certain number of races per day. So essentially, all of that is dictated by the commission. But to my understanding, the commission has never been put in a situation, and it's even unclear whether it has the authority to even tell these tracks, you have to either scrap those entries, or you have to force these, you have to allow these horses to enter and add another trial race.
Who are the stewards employed by? They're by each track, correct?
No, sir. Although they are listed as the board of stewards of the Rio Doso Downs, they are actually commission employees. So they are state employees, and they do act in a quasi-judicial capacity. They render decisions on discipline. They make decisions on scratching horses. They take care of all sorts of administrative aspects. So as we set forth in our response to the motion for sanctions, respectfully, they are entitled to quasi-judicial immunity.
Yeah, and I'm not worried about listen, that's a civil case that I'm not touching. That has nothing to do with this instance. If there was a violation of the Mexico Civil Rights Act, whether they're immune from that would all be advisory opinions that you guys can write about it all you want. It's not something I'm concerned about because it's not.
I'm sorry, Judge, for the interruption.
Go ahead.
Judge, I'm glad you mentioned that, because you talked about, well, what remedy do they have? Well, in terms of being able to enter and run, no, they don't have that remedy, because essentially that would upset the already set trial races. They've already been advertised. The public is already relying on that information. That would cause sheer chaos and open up petitioners to possible legal action against them by the 280 owners and trainers that had clean records or clean licenses that entered, as well as possible legal action against Rio Doso Downs, the Downs of Albuquerque, and the Racing Commission. Now, in terms of what remedies do they have? Well, the remedies these petitioners have should not involve forcing Rio Doso Downs or the Downs of Albuquerque, who are not parties to this action, to allow them to enter and set up another race where they'll have a more competitive advantage in the trial times because there's only 6 horses. The remedy is
let's be clear about something when it comes to contempt.
Yeah.
That's just how you purge yourself from the contempt. Doesn't mean that I can't hold you in contempt for disobeying the order. And if you choose not to purge yourself from the contempt, you face the sanction of that. You would still have to face the sanction. I guess getting back to the issue of the contempt in general. So if the stewards work for the commission, who accepts the entries of the races and who controls the entries and who is actually going to get to race and race?
The entries and the decision on acceptance of entries is done by the tracks racing office. So here we have a situation where it's the Rio Doso Downs meet, but obviously given the unfortunate tragedy with the fires and floods that occurred, their live race meet is being run at the Downs of Albuquerque. So essentially it was the Downs of Albuquerque racing office and racing secretary who basically control and establish the entries.
And the secretary is employed by the track itself, not the commission.
Sir. Yeah, the racing secretary is an employee of the tracks. And they're the ones that establish when are the dates and times of the entries for various races, and essentially, so they control that process. So that's why it's critical.
Could the secretary have ignored the summary suspensions and just entered these horses anyways?
You know, they could have, but then, Judge, they would have subjected themselves to disciplinary action by the Racing Commission and the Board of Stewards, because that would have mean that they did not follow the rules, and therefore their licenses could be put in jeopardy.
So they had no choice but to follow the steward's decision.
In other words, Judge, yes, the Board of Stewards followed the rules, the racing office and the racing secretary followed the rules, and essentially that's all we're trying to do here, Judge, is essentially make sure that those rules are enforced. And of course, Judge, unfortunately, as I mentioned in our reply, in order to allow the horses to be entered on the entries that occurred on Sunday, August 2nd, essentially the commission had to break its rules to allow a summarily suspended trainer to be able to enter those horses. So the remedy for these folks is not basically forcing the racing office to allow them to enter days after the fields have already been set, giving them a competitive advantage in a race with only 6 horses. The remedy essentially is seeking remedy in another forum. For example, a civil rights claim or things of that nature. The remedy does not lie with basically throwing a huge race like this, which has already been set for the time trials, into chaos and potentially exposing petitioners to legal liability, as well as the tracks. And
to be clear, I don't think that I have the authority to order that. I think that I can hold you in contempt and tell you how you can purge yourself of the contempt, and whether you choose to purge yourself of the contempt or face the contempt sanction, that's up to you, right? If I find that my order was disobeyed, I don't have a police force that's going to go out and enforce my laws, right? What I can do is in under civil contempt is I can then impose a sanction based on the contempt. And if you want to not face that sanction, you have the opportunity to purge yourself of the contempt. And I can give you the grounds for which you need to do something to purge yourself of the contempt. But I don't think I could force in any instance you to force these horses to be into the race. I can make that the remedy in how you purge yourself from the contempt. And I know that it's a nuanced difference, but it's a significant difference.
Okay. And Judge, as noted in the filings regarding the request for sanctions and an order of contempt, obviously the elements are knowledge of the court order and, most importantly, an ability to comply. When the commission received that order late on Friday, July 31st, obviously it was impossible to comply with respect to the All-American Futurity entries. Why? Because
Mr. Monte, let me pause you there, because what I'm going to do, if right now I haven't even issued the order to show cause. That would be for the evidentiary hearing if I issue the order to show cause. I'm not saying I'm holding anybody in contempt. I'm not saying any of that. And so the reason I set this for a hearing is to determine whether or not an order to show cause should even be issued. If you're going to present evidence at the related to the contempt, that would need to be at a future hearing where I set an order to show cause.
And Judge, There was no willful noncompliance on the part of the Board of Stewards or of the New Mexico Racing Commission to not comply with the Honorable Court's order. We complied with the portion of the order where essentially the reality of the calendar allowed us to basically do that. In other words, those entries that occurred on Sunday, August 2nd. And the Board of Stewards literally went into full overdrive to ensure that that order was complied with, even going to basically going to efforts to reach out to California and get that hold lifted on Revolutionary V, as well as do work to lift the other hold. So there was no willful noncompliance whatsoever. Judge, the reality is that the commission just had the inability to comply with the entries that occurred prior to the entry of the TRO, mainly because of the rules of the race. The need for certainty and completion in the most important thing of the entry of a race, the determination of the fields for the trials, and then the running of those trials, which occur on August 1st. So that certainty is absolutely necessary for the basically smooth operation of these races and to avoid potential legal liability from the betting public, the fans, and most importantly, those 280 owners and trainers who had licenses that were in good effect and properly entered within the time frame.
When did the first trials run?
When do the first trials run? The first trials run tomorrow, and I have my and for what races? The first trials run tomorrow for the All-American Futurity.
And do all of the trials go that day?
No. And Friday and Saturday. And Judge, just to clarify, on August 1st, there were no entries whatsoever for any All-American races. I just want to make that clear.
I understood that for the futurity. I understood that.
Correct.
The only delay was the two on the 31st of one needing a vet certificate from California and the one with ownership paperwork. I understand that from Mr. Montez's affidavit.
Yeah. So,
right.
so again, you know, these finals are these trials are already starting. So again, you know, the need for certainty is very critical here. And the way that you provide certainty is by, here is when the entries open, here's when they close, period, end of sentence. If that is disturbed, Judge, then essentially a Pandora's box is open where literally you never know how many trainers and owners will, well, I want the Valeriano exception.
Well, again, Mr. Bustamante, I don't think I can order that. I think that the only thing I can do is make that a way to purge the contempt if I were to issue contempt. I don't think that I have the authority to order you at this stage. I think I could have enjoined you from preventing them from entering, which is what I attempted to do. But I don't think I can now order you under the law. I am unaware of any authority that would allow me to order you to enter these horses. I can hold you in contempt, and I can enter sanctions and give you an opportunity to purge your contempt under civil contempt. Otherwise, it's criminal contempt, and then intent does apply, and then people would be entitled to due process and jury trials and counsel and all of that. And it would take prosecution from a DA's office or some other entity. The court can't do that by itself. So that if it's going to be a civil contempt, which is what I'm being asked to do, the remedy would only be an opportunity for the person held in contempt to purge himself from that contempt. So I'm not going to say that I have that authority, but I'll let Ms. Valencia respond to that. Ms. Valencia, if you think I have that authority, where does that authority come from in contempt sanctions? I think I can give them the opportunity to purge, but there's nothing that says that they have to purge themselves of the contempt, correct?
Your Honor, I don't have that information in front of me. There's not a rule I can recite as to that fact.
Okay. Did you want to respond to anything that Mr. Bustamante said?
Yes, thank you, Your Honor. If what he mentioned in regard to certainty for the race, I can have the petitioner testify as to how late entries are accepted. It is a common practice. So if what he's saying is a clear-cut line, well, there's exceptions to that, and the petitioner can testify as to that. Also, I'm just looking over my notes. Again, with them requiring like the immediate danger, if there was an immediate danger that existed, Mr. Valeriano has run over 50 races with 28 horses, and there was no bad test that ever existed. So if there had been any concern prior, then we would understand, but none of that was ever raised prior to the date of August 30, I apologize, July 31st. And further, Mr. Valerio and Mr. Garcia have been negatively impacted by this action because, as Mr. Bustamante stated, there is no solid evidence. The hearsay evidence that they have doesn't specifically name, for example, Mr. Garcia. In the reports, Mr. Bustamante clearly stated that it was alluded that it was him, but didn't specifically name him. So the harm is ongoing. And Your Honor, lastly, the rule 15.2.1.9 A6B, it states the steward shall allow for a full presentation of evidence and are not bound by the technical rules of evidence. The steward may admit hearsay evidence if the stewards determine the evidence is of a type that is commonly relied on by reasonably prudent people. The rules of privilege recognized by the state law apply in hearings before the stewards. Hearsay evidence alone is insufficient for the basis of a ruling.
Right.
And Judge, if I may make a few points for the record, sir.
Go ahead, Mr. Bustamante.
All right. Judge, in our last discussion with each other, you did mention about, the possibility of contempt and how to purge contempt. And Judge, obviously, the only remedy for that is the remedy basically that the petitioners seek is require the entry of those 6 horses into the All-American Futurity trials, which again have already been established and set. And again, the difficulty with that, Judge, is that, as I mentioned, is that because this issue, to my knowledge, has never been presented to the New Mexico Racing Commission, it is unclear whether the commission's regulatory authority extends to the point where it can basically order the Downs of Albuquerque Racing Office on behalf of the Rio Doso Downs live race meet to essentially upend those fields, add another horse, another race, reprint all that information and conduct it that way. So it really is a question of, does the commission even have the authority to do that? And it appears not, because those types of issues are controlled by the racing offices at the track. And again, that is why it's very critical and perhaps fatal to petitioners' cause of action here that they chose not to name the Downs of Albuquerque or Rio Doso Downs to their petition for a TRO. And the commission is of the mindset that there is no authority that we know of that would allow us to basically interfere that much with the operation of a live race meet and literally upend a huge race and the trials that have already been set and that information has already been disseminated. So that is the dilemma that we are in.
But if that dilemma was created by the agents of the commission, I'm less sympathetic, right, Mr. Bustamante? And so let me just cut to the chase where I'm at. Ms. Valencia, let me ask one more question. You've asked in paragraph C of your remedy for orders to show cause for me to issue show cause on Mr. Bustamante, Mr. Waxler, Mr. Trejo, David Dominguez, Ronald Frazier, and Violet Smith individually. I don't have personal jurisdiction over any of those because they've not been named to this petition and they've not been served. And so I don't think that I have the authority to issue an order to show cause on any of those. Do you have any authority that would suggest that I could issue? Because ultimately the show cause order is to show cause why the named entity in the order didn't comply with the order. None of those individuals were named in my order. How would I have jurisdiction, personal jurisdiction over them to enter contempt sanctions against them individually? I may for the Racing Commission as a whole. I may for the entire stewards of Ruidoso Downs, but I don't know how I have the individual authority. And are you aware of any legal authority that would allow me to issue an order to show cause for non-parties who haven't been served? And it's the same due process concerns that I have related to the lack of hearing in this case. They would have had an opportunity to respond. They would have an opportunity to have legal counsel, all of those same issues. And so how do I issue individual show cause orders against these folks?
Your Honor, I don't quite have the rule right in front of me. It's something that I can provide if I'm allowed a recess. But from what I do understand, the Racing Commission controls all of the racings and sanctions all of the racing.
Which is why I can hold them in contempt.
Yes, correct.
And so what I'm going to do for the parties is we're going to have a show cause hearing. The show cause hearing is going to be directed specifically to, I have not had the Board of Stewards of Ruidoso and Downs enter in this case. I don't think I have personal jurisdiction. I don't know that they've been served. The New Mexico Racing Commission by filing pleadings has entered, it has submitted itself to the jurisdiction of the court. And so the show cause hearing will be related specifically to the Mexico Racing Commission. There's going to be a lot of questions and it's going to be an evidentiary hearing, and I am really pressed for time in the next couple of days, but we're going to have to start this at 3:30 tomorrow. I don't have any other time to be able to do it. To also, if I end up giving a sanction, how the respondents would be able to purge themselves of the contempt. I'm going to give them that opportunity to look into that. As Mr. Bustamante said, this might be a matter of first impression and he might have additional defenses. I want to be very clear. I am not taking argument from any lawyers related to what occurred. You all need to be ready to present me with actual evidence at this show cause hearing. If there's a defense of impossibility to comply and you want to present that, Mr. Bustamante, have the people here to tell me that testimony. Ms. Valencia, whatever witnesses you want me to hear from, including Mr. Valerio or anybody else who was engaged in conduct trying to get these horses registered, and the practical situation of, you know, when did the entries close and when was everything drawn for the races, all of that. I have to have an evidentiary record, because regardless of what I do, you all are going to appeal or might appeal or file a petition for writ of error or whatever you want to do. And we need to make a good record for the appellate courts to be able to review whatever actions I do. So you all need to be prepared at 3:30 to present evidence. It might mean we might be going past 5 p.m. tomorrow. So you all need to be prepared that the day may not end exactly at 5. The other thing that I'm going to do today is I'm going to deny the supplemental respondents. The supplemental verified petition for emergency temporary restraining order and preliminary injunction as to Raymond Valerio and Manuel Garcia. I'm denying that because there's going to be a hearing this afternoon that complies with due process. And I'm going to deny the petition to extend the restraining order or entry of, so it's the petitioner's emergency motion to extend temporary restraining order, or in the alternative for entry of a preliminary injunction. I'm going to deny that as well, since there's going to be due process hearings this afternoon. Mr. Bustamante prepare orders denying those two. Ms. Valencia send out a proposed order to show cause for the New Mexico Racing Commission. We'll enter that, but I'm giving everybody notice now. It'll be held tomorrow starting at 3:30. Use the same Google Meet that you're on right now to log in tomorrow at 3:30.
Judge, one other matter.
Bustamante.
Thank you, Judge. the matter of the commission's motion for clarification regarding your TRO order, specifically paragraph C, it says that the order does not disturb the summary suspension of Valeriano, his personal license, does not disturb the exclusion of Mr. Valeriano from commission grounds, and does not prevent the summary suspension hearing set for August 6th from proceeding. Is the commission correct in apply that those conditions also apply to petitioner Valerio and petitioner Garcia?
I've never restrained the commission related to Garcia Valerio, so this order is inapplicable to them as a whole.
Okay. All right. We were just concerned, Judge, because they are listed in the case caption, but not mentioned anywhere else in the order.
Correct. And to be honest with you, when I read the petition, I wasn't sure if they had even been suspended. That's why the order doesn't address them. And I'm denying the request to enter a TRO today because of the hearings that are going to happen this afternoon.
Okay.
Ms. Valencia?
Yes, thank you, Your Honor.
Go ahead.
Yes, I'd like to add that Mr. Montes told the court at paragraph 20 that the field is finalized and completed when the entries close. The respondent's own condition book, their document, not mine, says both days of trials will be drawn Saturday, August 1st. Entries closed at 10:30 on Friday morning. The court signed the order at 4:46 Friday afternoon. The draw was the next day. I do not suggest that Mr. Montes intended to mislead the court. I do say the premise of the impossibility argument is not correct, and the document that shows it came from the respondents.
Well, and that's going to be an evidentiary condition that I'm going to have to take up during the show cause hearing because, like I said, that in no disrespect, I think your arguments are helpful for me in making my decision, but it's not evidence, right? So on an appellate record, whatever you all say, the appellate courts are just going to say argument by counsel is not evidence. It's just argument. I need actual evidence. And so present that evidence. And you know, what I will ask is that, Ms. Valencia, are there specific officials with the Racing Commission that you want present? And I'll ask Mr. Bustamante to make sure they're available for examination during the show cause.
Your Honor, is there, can I submit that in writing?
Yeah, I'll give you until 2 p.m. today. And Mr. Bustamante, if there's specific other than the petitioners themselves, individuals that you believe are necessary from the petitioner side, you should have that same opportunity by 2 p.m. to submit a list that you're asking Ms. Valencia to prepare and have those individuals present for the show cause hearing. The reason I'm trying to do this so quickly is because the races run Saturday at the latest. And so we've got to try to get a decision Friday afternoon and give you enough time to prepare for that. So that's why I'm going to ask both counsel to work together to provide witnesses. We don't have time to issue subpoenas. I could do a show cause order later, but then there's not going to be an opportunity to purge themselves from the contempt. And so if I issue the contempt, I'm not saying I'm going to, I'm just saying that there should be an opportunity to purge themselves of the contempt. And that's probably what the petitioners would like anyways, is an opportunity for the respondents to choose if they feel like they have that ability to. And I'm not making any of those decisions. They're completely up in the air. We'll decide those tomorrow at 3:30.
Okay.
Your Honor, also the respondents told the court they lacked the ability to comply. Their own rules say otherwise. The racing secretary who receives entries is a racing official, and the commission licenses in sole discretion. And 15.2.3.8B1 says that the steward's authority includes supervision of all racing officials. The stewards are responsible to the commission for the conduct of the meet. And Mr. Montes' own paragraph 11 describes the board of stewards reviewing papers and an entry being finalized at 11:30 in the morning after the close. He calls it common and regular process. The commission did not need to run the entry window. It only needed to tell its own officials that the district court had restrained it.
Well, and I've got certainly questions for Mr. Montes, and you know, there's evidentiary questions. You know, I appreciate the affidavits that give me perspective, but they're not going to be entered into evidence. They'd be hearsay. And so that's why I need the direct testimony of these individuals. But, you know, Mr. Valerio, Ryan Valerio has submitted an affidavit that he was attempting and having conversations with Mr. Montes. And if it contradicts, I'm going to have to make a decision based on the testimony of who's being truthful, who's not being truthful. And I can't do that through affidavits. I can only do that through examination and cross-examination. So that's what I'll do.
Yes, Your Honor. Lastly, I just want to state the statute, 60-1A-4B1. The commission shall make rules to hold, conduct, and operate all races and meets and horse races held in the state and to identify and assign racing dates, not some, all.
Mr. Bustamante, you've been itching to say something.
Judge, first of all, thank you so much for all the time you've given us. Judge, I just wanted to let you know that as I mentioned earlier, there is the case of Bolin versus New Mexico Racing Commission, which essentially stands for the proposition that the commission officials, the board of stewards, are quasi-judicial officers, and so therefore, respectfully, we will object to any request by petitioner's counsel to basically get the individual stewards on the stand and present them for questioning, cross-examination. Essentially, as quasi-judicial officers, we basically feel, just as judges should be prevented from being put in the position of having to explain their deliberations and things of that nature, we would clearly fight against the opportunity for petitioner's counsel to question the board of stewards, given their quasi-judicial function and their need to basically have the ability to exercise their quasi-judicial functions without fear of retribution or things being held against them.
I'm not going to rule one way or the other of whether or not that would actually entitle them from having to testify. I think there are circumstances, even with immunity, that judges can be compelled to testify about certain things. And I think that the same is true of stewards. They could be compelled on certain circumstances. But if either one of you wants to provide briefing as to that issue, you're more than welcome to do so by 5 p.m. today. And I'll certainly read whatever cases you tell me before 3:30 tomorrow. But I'm not going to make a ruling one way or the other. I do think that there are instances where they could be compelled to testify, not necessarily about the judicial, quasi-judicial decision of why someone was suspended, but as to the actions that occurred, like the factual determinations of what occurred the morning of August the 1st. I think they probably could be compelled to testify as to factual issues, not judicial determinations, not why they made decisions that they made, but what occurred and what times. I think they could be compelled to testify to those issues. But if you disagree, Mr. Bustamante, feel free to provide me some briefing and I'll take a look at it. Ms. Valencia, you're more than welcome to respond to it.
Thank you, Your Honor.
All right. I've got an 11 o'clock that I'm 3 minutes late for, so we're going to go off the record. Thank you all.
Thank you.
Thank you, counsel.
Thank you.